As of July 17, 2026, the H-1B door for this year is officially closed, and if your registration wasn't selected, there will not be a second chance until next spring. USCIS confirmed it has received enough petitions to fill all 85,000 slots for fiscal year 2027, 65,000 under the regular cap, and 20,000 under the advanced degree exemption, and there will be no second lottery round this year. If you're an F1 student on OPT, an employer sponsoring talent, or someone still waiting to hear back, this video walks you through exactly what closing the cap means, why this year's odds looked completely different from previous years, and the 5 backup paths people are actually using right now to stay legally employed in the US while they wait for another shot. Stay till the end, because one of these 5 options is being called the most underused strategy of the year, and almost nobody explains it clearly. Plus, I'll walk you through exactly what to say to your employer this week if you were closed out. Here's what actually happened this cycle. USCIS received roughly 211,600 unique registrations, down nearly 39% from the 343,981 registrations submitted just the year before. Fewer people entered, but that didn't make it easier, because this was also the first full cycle under the new wage-weighted selection system. Instead of a flat random lottery where every registration had equal odds, DHS now gives higher-paying job offers a statistically better shot at selection, based on Department of Labor wage level data tied to the role and location. And the results already show it clearly. 71.5% of selected beneficiaries this year hold a U.S. advanced degree, up from 57% the year before, and only 17.7% of selections came from the lowest wage tier. If you're a recent graduate on a starting salary, that shift works against you directly, and it's exactly why so many strong, qualified candidates got closed out this year, even though total registrations actually dropped. If your petition was selected and properly filed by the June 30th deadline, you're set, and you can begin working under H-1B status starting October 1st, 2026, once your petition is approved. If you weren't selected, your status updates to not selected, and USCIS will not run another round, no matter how badly employers want to file more petitions or how strong your resume looks. The next opportunity to register for the cap is expected in March 2027 for the FY2028 cycle, which means anyone counting on a fallback lottery this year is out of time, not out of options. Let's go through what's actually available right now, because not selected does not mean out of the country, and it does not mean your case is closed. First, and this is the one most people overlook completely, cap-exempt H-1B employment. Certain employers are not subject to the annual cap at all, including universities, nonprofit research organizations affiliated with a university, and government research organizations. These employers can sponsor H-1B status year-round with no lottery involved, no March deadline, no waiting for next spring. If you can find a role at one of these institutions, even a temporary or lower-paying one compared to industry, you bypass the entire cap system entirely. And here's the detail most people miss. In some cases, you can hold concurrent employment, meaning you work part-time or full-time at a cap-exempt institution, while also working for a private cap-subject employer, as long as the cap-exempt position remains active and genuine. That single detail has kept more careers on track this year than almost any other strategy. Second, if you're on OPT with a STEM-coded degree and an E-Verify registered employer, the STEM OPT extension gives you 24 additional months of authorized work. Just as importantly, it gives you up to 2 more attempts at future H-1B lotteries without having to leave the country or change your status while you wait. This is your runway, not your final destination, but it buys you real time to build a stronger case, gain more experience, and potentially move into a higher wage bracket that helps under the new weighted system. Third, the O-1A visa, for individuals with extraordinary ability, is worth a serious look if you have any external recognition in your field. Awards, published work, media coverage, patents, speaking engagements, or a documented track record of original contributions. It's not about being good at your job. It's about proving distinction with evidence. And this year, More attorneys are actively steering unselected candidates toward O1A specifically, because approval rates have stayed strong, even as H-1B selection has gotten harder and more competitive. Fourth, if you're a Canadian or Mexican citizen, the TN visa remains one of the most reliable and fastest alternatives available anywhere in the system, with none of the cap or lottery complications tied to H-1B at all. And processing that can move in weeks rather than months. Fifth, for multinational employers, the L1 intracompany transfer visa lets an employee work abroad for their company for at least 1 year and then transfer directly into a U.S. role, a path some candidates are now planning years in advance, specifically because they've watched how unpredictable the H-1B lottery has become under this new system. And if your long-term goal is a green card, regardless of H-1B, some candidates are bypassing the employer-sponsored route entirely through EB-2 with a National Interest Waiver, which lets you self-petition without needing an employer, a labor certification, or an H-1B at all. Something I broke down in more detail in an earlier video on this channel about the F1 to green card pathway. Now let's talk about the actual conversation to have with your employer this week, because a lot of candidates go silent after a rejection instead of pushing the discussion forward. Ask directly whether the company has any cap-exempt affiliations or research partnerships that could support a concurrent role. Ask whether they'd consider sponsoring an O1 if your background supports it. And if none of that applies, ask for a clear timeline on re-registering you for the FY2028 cap next March, in writing, so it doesn't quietly fall through the cracks over the next several months. Employers deal with dozens of these conversations every cycle, and the candidates who ask direct questions early are consistently the ones who end up with an actual plan instead of just a wait-and-see approach. Now, the mistakes people are making right now, because these matter as much as knowing the options exist in the first place. Waiting until March to start exploring alternatives instead of acting in the next 2 weeks. The candidates who land the strongest backup positions are consistently the ones who move immediately, not the ones who wait and hope something changes on its own. Assuming STEM OPT alone is a long-term solution, it's a bridge with a hard expiration date, not a replacement for a real status plan. And burning through it without a parallel strategy just delays the same problem by 2 years. Overlooking cap-exempt employers because the pay is often lower than industry roles. That trade-off may genuinely be worth it if it keeps you legally in the country, working, and building toward your long-term goals instead of losing your status entirely. And relying on a single strategy instead of pursuing 2 or 3 of these paths in parallel, because the person who only tries one option and watches it fail has burned time they cannot get back, while the person running multiple strategies at once almost always lands somewhere solid. One more thing worth knowing before you go. The 100,000 H to 1 billion petition fee that made headlines last year is still tied up in ongoing litigation, and as of the most recent guidance, it is not currently being applied to any cases, though that could change again depending on how the court proceedings move forward. So if you're weighing a cap-exempt filing, an O1 petition, or any alternative route right now, that fee is not a cost you should assume you're facing today, but it is something worth monitoring if you're planning further out. If you take one thing from this video, let it be this. Not selected is not the end of your timeline. It's the point where you need a second plan moving faster than your first one did. Talk to your employer or your immigration attorney this week about which of these 5 paths actually fits your specific situation, your degree, your field, your nationality, and your employer's willingness to explore alternatives. Because the option that works for one person, closed out of this lottery, might be completely wrong for the next person reading the exact same headline. This reflects general information about immigration rules as of 2026. It's not personal legal advice, and every case depends on individual facts. So speak with a licensed immigration attorney about your specific situation before making any decisions. If this video helped you see a real path forward after getting closed out this cycle, subscribe to the channel, because FY2028 registration opens in March, and there's a lot more to break down on wage levels, cap-exempt sponsors, and what's actually working for people right now before that window closes too.